What are the legal consequences of being caught driving under the influence of alcohol or drugs in Spain? And what happens after being arrested? Especially when a criminal accusation could be made against the driver, there are certain details to be taken into account. Criminal proceedings may follow in two cases, according to the Spanish criminal law. In all cases, when the breathalyzer test rate exceeds 0.60 mg per liter. Secondly, in those cases when the driver's faculties for driving are clearly affected by the ingestion of alcohol or drugs, even in those cases when the rate is below 0.60 or when no test can be carried out. Most of these criminal proceedings end with signing an agreement with the prosecutor, the driving admitting his fault and accepting a penalty with a reduction from the initial charge. In these cases, the lawyer representing the driver will negotiate with the prosecutor the best possible agreement, and finally this agreement will have to be ratified by the driver before the court with the assistance of a translator if it's necessary. This doesn't mean that this kind of cases cannot be defended before the court and to obtain a dismissal of the charges. For this purpose, it is essential that the lawyer representing the driver studies in depth all the documentation and the information included in the court file. Normally, in these cases, formal defects or formal mistakes are the best option for the defense strategy. These formal mistakes could affect, for example, the formal report to be issued by the officers, the court notifications, or the certificate of the breathalyzer. Finally, it is important to underline that it is not recommended to refuse to complete the breathalyzer test. In those cases, when the driver refuses to complete the test, it would constitute an independent criminal offence apart from the previous one, and it would carry further complications for the driver.